Hi, Luis. Good morning.
All right, Judge, bottom, from top of four, Cobble. Come on up. Go around.
Go around. We don't want you guys near the DAs. That way. Mr. Cobble, you are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 18, 2026, Harris County officer dispatched to a family assault call. Upon arrival, the complaining witness advised that her husband had straddled her on the bed and began punching her in the face twice, causing pain. Officer observed red bruising on the left side of the complainant's cheek.
We have one that was dismissed in August of last year. Is it the same complaining witness? And then he also picked up a felony assault right afterwards. All same complaining witness?
Yes, Judge.
Our assault here, tell me, is it dismissal and a refile, or is it a true new assault?
This is a new assault. This is not the same as the old one.
Mr. Cobble, I'm going to find that there's probable cause to go forward with your case. This is not a revolving door. His bond is set at $1? Hell no. No, you're going in today. Absolutely not. This is not a revolving door. And let me tell you something. You put hands on anyone else, I'm going to go bananas on your bond next time. Don't send him down, please. If you can appoint him a lawyer.
Okay, this.
Well, hold on. Mr. Cobble,
Yes.
you are not to have any contact with the complaining witness in this case, and I'm going to put a monitor on your ankle so stop. I'm going to put another monitor on your ankle so I know where you are at all times. And if you should put hands on anyone else, I'm telling you, I will have a hearing to hold you at zero bond until these cases are over. Do you understand? No weapons, no going within 2,000 feet of where this complaining witness lives, works, or breathes. Can you put the device on the ankle so that she's notified in the event that he goes close or near the complaining witness, please?
She had to wear a Miss device in order for her to be notified.
No, there's something that we can put on the actual GPS so that it alerts in the event that he goes within 2,000 feet. It notifies her, and then she can call. I don't know, I guess look into it and we'll see, but let me make sure there's a protective order that's in this thing.
I haven't been issued, but there's not much.
Okay, I need him one more time. Just, Mr. Cobble, I don't know how, but I am now issuing what's called a magistrate's order of emergency protection that identifies Ms. Cobble as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 2,000 feet of where she lives or where she works. If you violate this court order, the state can and will file a violation of protective order, and that is the capital murder of misdemeanors. Do you understand?
Yes, sir.
When I mean no contact, I mean no contact of any kind. I don't care if she reaches out to you. I don't care whoever Jesus tells you to do something. Don't have contact and don't go near this person.
Yes, sir.
All right? Okay, just don't send him down because we need him. The felony assault, is it as the same nature as here? Is it just, is it more aggravating?
It's a continuous, Judge. It's part of this one, and then Not more aggravated. but-
Such as beating her up again, allegedly. Okay. Counsel, you ready?
Yes.
Good morning.
Good morning, sir. How are you?
Just, last name of your client.
Castro.
Cash.
I don't know, Susan, how much is the bond for this one?
I don't know yet. I'm gonna get a lawyer involved and then we'll go from there.
Okay, sounds good.
Castro, come up. All right, Mr. Castro, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On May 2nd in Harris County, around 12:42 in the morning, officer observed a motor vehicle to be within its lane, drive over a lane marker, and then make a wide right turn on the 700 block of East Boulevard. Officer initiated a traffic stop and observed the defendant, the driver, to have a moderate odor of alcoholic beverage and blocked eyes. The defendant also admitted to having a beer, 1.5 beers. SFSTs were conducted, 6 out of 6 HGN, 4 out of 8 walk and turn, and 2 out of 4 one leg stand. DIC was read, breath test was conducted, results were 0.112.
Any prior DWIs, license?
No prior DWIs, judge, the license is eligible.
Okay, Mr. Castro, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. I'm not asking much from you. Just don't use and everything will be well. Don't endanger our community. Do you understand? You're not allowed to drive unless you have a valid Texas driver license. You must also maintain liability insurance in your name. If you do not have car insurance, then do not drive. Do you understand? Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with him. You don't have to waste your time coming to court, but he'll tell you if and when you have to come back to court. If he tells me he cannot get a hold of you, likewise, your bond gets revoked. You understand? Okay, we'll have you sign a reset. You'll get with Veronica for your bond conditions, and then you're good to go.
Thank you, Judge.
Thanks. Take care.
All right, Judge, bottom of 14,
Good morning, Marcos.
How are you, Judge?
What's up? Paz. Okay.
When they're alone.
So we're going to stage left.
Good morning, Mr. Paz. So you're charged with, I don't even know, what is it? Driving while intoxicated. You're facing up to a year in jail because of the high blow and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On May 3rd in Harris County, Texas, officer conducted a traffic stop on a vehicle that was traveling southbound on the northbound lanes of Highway 6. The driver was identified as the defendant. Officer noticed a strong odor of alcoholic beverage from his breath and red glossy eyes. Defendant admitted to drinking 6 Modelo's and to driving the vehicle. SFSTs were conducted. 6 out of 6 HGN, 6 out of 8 walk and turn, 2 out of 4 one leg stand. DIC was read and defendant provided a breath sample. Result was 0.217 and 0.215.
What did you say the stop was for?
Motor vehicle traveling southbound and the northbound lane.
Oh, he's going the wrong way. Mr. Paz, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you have a license to drive? Any
There's no
priors?
license on file, Judge.
Any priors?
No priors.
Okay. You do not have a Texas driver license. You are not allowed to drive. I don't care what you have to do in this life. You will be signing an affidavit with me. This is a promise that you're going to make to me that you're not going to drive. I don't care that you need groceries. I don't care that you have to go to school. I don't care that you have to work. If you don't have a license and insurance, Texas driver license, then do not drive. Do you understand? I'm not going to warn you again. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they will put a detainer on you and you will sit in custody for a very long time. And then you'll get shipped off to immigration, or you will sit for another long time. Do you understand?
Yes, sir.
Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Marcos. For now, I'm going to have you swear to us that you're not going to drive. I'll get you to sign a reset. You'll get with Veronica for your bond conditions, and then you're free to go.
Thank you, Judge. Maybe 6.
Thanks, guys. Yeah.
Council approaching for top of 7, as far as the.
Hi, good morning.
He's swearing up on that he will not offer the word that.
It should be.
All right, you are Miss Claudia Esparza. Ma'am, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you.
On May 3rd in Harris County, around 2:23 in the morning, officer observed a motor vehicle traveling without any tail lamps that failed to stop at a designated stopping point and then make a wide right turn. Officer observed the motor vehicle to then swerve in its lane and then drive over marked lane lines. Traffic stop was conducted. The defendant, the driver, advised that she was leaving a beer garden. Officer observed red glossy eyes, slurred speech, and an odor of alcoholic beverage from her breath. SFSTs were conducted, 6 out of 6 HGN, 5 out of 8 walk and turn, and 3 out of 4 one-leg stand. DIC was read, fused, and blood search warrant was executed. Blood was drawn.
Does she have a license to drive?
She does, Judge, it's eligible.
Okay. Mrs. Sparks, I'm going to find that there's probable cause to go forward with your case. Because this is the second offense, I'm now placing an additional restriction on your driver's license. You're not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If I find that you drive a vehicle that doesn't have an interlock, I will revoke your bond, put you in jail. No more PR bonds for you. Do you understand? As a condition, you're also ordered not to consume alcohol or illegal drugs. This includes marijuana. You will be tested. If you test positive for anything, your bond will be revoked into custody. Like I said, it's not a revolving door. Do you understand? Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with her. She'll tell you when you have to come back to court. For now, we'll have you sign all the documents, and after that, you'll be free to go.
Thank you.
Please. And then the guardian interlock. Okay. Got it.
All right, Judge, next, and top of 5, Cooper, come on up.
Good morning, Mr. Cooper. Sir, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On May 2nd in Harris County, officer dispatched to a disturbance call at a motel. The complainant and the defendant were detained on scene and separated. The complaining witness advised that he was struck in the face by the defendant with a closed fist and that he felt pain. Officer reviewed video footage provided by the motel manager showing the defendant in front of the complainant's driver's side door, yelling at the complainant with a closed fist and then leaning down towards the complainant, striking him with the right hand. Complainant then struck the defendant with his cane.
The complainant struck him with a cane.
After he was hit in the face. Yes, Judge.
Do we know the relationship between the two?
We do not, Judge, not in the dims.
And you said it's a motel.
Yes, Judge.
All right, Mr. Cooper, you have the right to remain silent. Exercise that right. I know you want to fight the case. Now it's just not the time. Whatever you say, they're going to use it against you to prove guilt. You'll have the opportunity. It's just now it's not the time. But I want you to understand that I'm going to protect my community. I don't know who you have in this life, but if I have to revoke your bond and I make your bond $20,000, you don't have anyone to pony up that kind of money. You'll be stuck like Chuck with me for who knows how long. Do you understand? So as a condition, you're not allowed to go back to this motel. You're not allowed to have contact with the complaining witness and not to be in possession of any weapons. You understand? Okay. Tell me, do you have the ability to hire a lawyer? How do you support yourself?
I drive 18 wheel across the country, so I drive 18 wheels.
So you make good money, driving 18 wheelers, no?
But I got a lot of grandkids there.
I get it, but you know, this life is not how much money you make, it's how much money you spend. If you spend beyond your means, Harris County is not going to pay for you just because you spend a lot, you know? To qualify for an appointed lawyer, you have to be at the federal poverty guideline, which is around 16,000 a year. You understand? Do you think you're going to qualify for a court-appointed lawyer? I'll have you fill out an application. I need to know everything about you, how much money you have coming in, all other sources of income, what kind of cars you have, stocks, bonds, mutual funds, IRAs, and I'll take a look to see whether you qualify. Don't leave it blank and be honest because you're going to be swearing to it. Okay. So we're going to have bond conditions created for you to sign. Do not leave until you sign our bond conditions. Do not pick up any new cases. Do you understand?
Can you go to work?
No, you can go to work. I'm just saying, don't be a danger to the community.
No.
I'm not asking much. All right. Deputy Williams will give you an application and we'll have you take a seat at jury box. Marcus.
When I was here before, I apologize. I forgot to ask you, I have a Juan Velasquez on the docket, judge, just a PDR. I get rid of him on what if I can hold him Monday. Okay.
No, it's on them. I'm gonna end up revoking it and then just let me know if you get a hold of him. Let me
Okay,
see.
okay. I will, judge. Thanks.
Yeah, okay. Thank you, buddy.
You have a program
Yeah, Carl Moore.
Good morning, Judge.
Great to see you, man.
Good to see
It's
you.
been way too long.
Happy
The
Friday.
celebrity.
Nice.
What's up?
I'm here on, it's in arraignment. So last week, she had a warrant outstanding for a while. We were gonna approach to get the bond set.
Damn.
And then we realized the bond was already set. So I sent her to a bond. They made the bond. The case was set for today.
Okay,
Her mother asked me earlier this week, could I move it off docket? They live in Lake Charles. I told her I would, and then I didn't remember to do it until 4:45 yesterday. So she's not here. I'm asking the court, because it's really my fault, if we could set it for a bond forfeiture sometime next week.
okay.
So that she can.
Pick the
come.
day, but understand the case is 2,470 days.
She's been in the wind, I guess would be the correct term, or an absconder for all.
Sure,
the
of
time.
course.
I was recently hired, so.
No,
it's
I get it.
Yeah.
I'm happy that you're on it, but
We're gonna
we need
keep it
we need to fast track it. We can't just for another 6 months and
That's my plan, Judge.
do you have an offer on the case now?
I don't believe so, Judge. No, I can put one up.
Please. Let me see.
We'll work fast.
Yeah, I trust you.
She doesn't have any more responsibilities to me,
Let's
but
see. So pick a day next week, SFBF. If she doesn't appear at that point though,
fair. Thank you, Judge.
okay, you got a call.
All right, Judge, bottom of 12, Martinez, first name starting with a D.
All right, you are Mr. Martinez. So you're charged with reckless driving. You're facing up to 30 days in jail and or a $200 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On May 2nd, in Harris County, around 10:47 at night, officer observed a motor vehicle traveling at a high rate of speed, and while attempting to catch up, the driver turned his taillights and headlights off and reached speeds of 121 miles an hour in a 65-mile-an-hour zone.
Damn.
The vehicle also made aggressive lane changes, passing other motor vehicles. Traffic stop was eventually conducted. The defendant, the driver, and sole occupant advised that another motor vehicle was following him and that it scared him.
See the license to drive.
He does, Judge, it's eligible.
Mr. Martinez, as a condition of your bond, if I find that you drive like this, I will deem you a public danger. I'm going to throw your butt in jail and I'm going to make your bond really high. Do you understand?
Yes, sir.
Not only that, the DA's office has now started seizing cars at an alarming rate for people who pick up these types of cases. So the next time you may very well kiss that car goodbye. Do you understand?
Yes, sir.
How old are you, sir? What do you do for a living? Did you want to apply for an appointed lawyer? You want to apply for a court-appointed lawyer, or do you want to go hire a lawyer? You need a lawyer to represent you because you're facing time in jail.
I'll take one.
Okay, I'm gonna have you fill it out. I'm telling you now, don't screw around on the streets.
Sir.
Otherwise, it's just not gonna go well for you. You catch my drift.
Yes, sir.
This is not the Fast and Furious. Come on. So no reckless driving, et cetera, please.
Already filed.
All right, Judge, bottom of 13, Moreno.
Good morning, Ms. Moreno. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On May 1st in Harris County, officer dispatched to a Dillard's in regards to a theft. Complaining witness observed the defendant on surveillance walking into the store, selecting several items, concealing them on her person, and then walking past all points of sale, no intent to pay. The total of the items was $218.99.
Okay. Ma'am, there is probable cause to go forward with your case as a condition of your bond, no going to Dillard's. Do you understand? If you pick up a new case, if I find that you go back, I will revoke your bond, put you in jail. No more PR bonds for you, ma'am. No co-defendants?
No, Judge.
Okay. Do you have the ability to hire a lawyer? Okay. You don't want a court-appointed lawyer? Which one? Court-appointed lawyer. Okay. Deputy Williams will give you an application. We're going to have bond conditions created for you to sign. Do not leave until you sign them, and then we'll take a look at your application, all right? Please. No Dillards.
File.
Thanks.
Yes, Judge.
Bottom of 16, Rojas.
Good morning, Mr. Rojas.
Good morning, sir.
So you're charged with assault causing bodily injury. You're facing a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, sir.
On May 3rd, 2026, in Harris County, Texas, officer was dispatched to a convenience store for an assault regarding a male attacking a female with a knife. Officer met with complainant who appeared to be in pain, was dripping wet, and had a strong odor of bleach on her. Complainant stated she was riding her bike to the store when defendant, after a short argument, began hitting her bike with what she stated was a knife. Complainant walked away, defendant followed her, passed her, and walked into the store. When inside the store, defendant grabbed a bottle of bleach and threw it onto her face, causing pain on her skin.
And we're here in misdemeanor court?
Defendant stated complainant was trying to hit him and attacked him, and that's why he threw the bleach on her, because she was trying to run up to him and punch him. Officer reviewed security footage of the incident depicting defendant throwing the bleach at complainant.
Mr. Rojas, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. You're ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to test you like crazy to make sure that you're not using. In fact, you'll be tested within the next couple days. If I find that you're using, you will go to jail. I will protect my community at all costs. You endanger it. I have no problems making your bond $10 million. Do you understand?
Yes.
You are not to go back to the store. You're not to have contact with the complaining witness, and I'm going to put a monitor on your ankle today so I know where you are at all times. Do you understand?
Yes, sir.
We don't have any, the complaining witnesses in the 5 prior cases have no, it's not the same complaining witness, is it?
I'm taking a look, Your Honor. Looks like they're different complainants.
How do you support yourself, Mr. Rojas? When is the last time you've had a full-time job? J-O-B.
Nah, I never, but I do like it though.
Never.
I get me a job then.
No. When is the last time you've had a full-time job?
I don't know, like last 6 months, a year ago, I don't know.
You know exactly when you had the last time a job, Mr. Rojas. When was it? What year?
Last year,
It's time for you to start working full time. When people have too much time on their hands, they become what?
problems.
Self-destructive, Mr. Rojas. I'm bringing you back in a week, and I want to see at least 20 to 30 applications for full-time jobs. If you've done nothing, it's not going to go well between us. Do you understand?
I get it to 20 to 30, gosh, 30. I'll make
And
sure.
let me tell you something. We don't work on the gospel here.
Yeah.
I want proof.
No, no.
Do you understand?
Yeah, I got you.
I would probably think it's prudent to give due to curfew. So let's do 10 p.m. to 6 a.m. Deputy is going to give you an application for a court-appointed lawyer. You will sign a reset, and then I'm going to have you take your seat in the jury box. Let me tell you something. I'm going to keep you extremely close. One false move, it's not going to go well between us. Do you
Yes, sir.
understand?
Yes, sir.
All right, Judge, top of 19, State Miller. Joanne.
She go to the hospital?
I do not see anything that seems about that, Your Honor. I'm gonna give her a call.
Yeah, I mean, I'm curious, is there any kind of, bleach in the face is not, I mean, I'm sorry.
Top of 19, Judge.
All right, good morning, ma'am. Ma'am, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed.
On May 3rd, 2026, in Harris County, Texas, officer conducted a traffic stop on a vehicle that failed to stop at a red light. Officer made contact with defendant who provided an ID. The ID was not eligible, and further review found the defendant was operating the vehicle without proof of financial responsibility.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with your case. You were not allowed to drive. You do not have a license. You do not have car insurance. Do not drive. That is the only condition I'm placing on you at this time. I don't care what you have to do in this life. There's nothing that you can justify to get into a car and drive. Do you understand? If you want to drive, go get a license, get insurance. If you come back to me and show me, backflips to take this restriction off. But until that point, if you do, it's just not going to go well. Do you have the ability to hire a lawyer? Do you have the ability to hire a lawyer? How do you support yourself? Okay. Deputy will give you an application for one appointed lawyer. I need to know everything about you, how much money you have coming in the household, and then I'll take a look to see whether you qualify. I'm literally asking you just follow the law. I'm not asking you to split the atom. Please do not drive. All right? Come on.
Bottom of 22, Vega, system, come on up.
Hi, Pete. What's up?
I got dismissing the list, the grade on two on and two, he's on the jury box, I just telling, I'll be back in like 10 minutes.
Do what now?
Dismissal of you on, give you HON.
It's not, I don't, have I sent a dismissal on Duhan?
It's not my case, Leslie LeGrand asked me to step in, but he's in here, so I'll check back if you don't.
Yes.
Okay, it's been dismissed. I signed it already, so you can take it. Yeah.
Thank you, sorry
Sure.
about
Just like.
All right, you are Mr. Vega.
that.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On May 2nd, 2026, in Harris County, Texas, officer observed a vehicle attempt to switch lanes last minute, causing it to strike a curb and almost flip the vehicle on Washington Avenue. A traffic stop was conducted and officer made contact with defendant and observed slurred speech and the strong odor of alcoholic beverage from defendant's breath. Defendant stated he was coming from the underground hall and had a few drinks, specifically 4 shots. Standard field sobriety tests were conducted, 6 out of 6 HGN, 6 out of 8 walk and turn, and 4 out of 4 one-leg stand. The IC was read and defendant provided a breath sample. Results were 0.124 for both samples.
Does he have any prior DWIs?
No prior DWIs, Your Honor.
License?
I'm running his license right now, Your Honor.
I missed, what was the stop?
So the officer observed defendant attempt to switch lanes last minute, causing him to strike the curb and almost flip the vehicle.
Oh, got it. All right. All right, Mr. Vega, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. Your orders not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, I will revoke your bond, put you in jail. Do you understand?
Yes, sir.
We are going to reset your case to give you time to hire a lawyer. So I'll have you go to Victoria, sign a reset. You're going to get with Veronica for your bond conditions. You're not allowed to drive unless you have a valid Texas driver license. You must also maintain liability insurance in your name. If you don't have it, then don't drive. You understand? All right, come on.
And Your Honor, his license is eligible.
Great. Please.
Right, the council approaching for.
The Burns.
10.
Morning, Your Honor.
Okay.
September, Jack Yez is a DWI here in your court. It's an arraignment setting. She
You said
actually got her interlock installed today. She got that last. I got that.
good morning, ma'am.
I'm on this case and the felony yesterday. Bond conditions out arraignment. I know you want to do your own thing and have both.
Yeah, I don't know. She's got something upstairs as well. I have no idea.
Yeah, and we did conditions on that if you all, but I think those were not, those are specific to that case.
All right, ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, ma'am. Okay.
On May 3rd, around 4:14 in the morning, officer observed a vehicle traveling at a high rate of speed to be making unsafe lane changes and failing to signal a lane change several times. Officer paced the defendant's vehicle for about a quarter mile and found a varied speed of 77 to 82 miles an hour in a 60 mile an hour zone. The traffic stop was conducted. The defendant was the driver and sole occupant. Officer observed the defendant to have glossy, watery eyes, droopy eyelids, blurred speech, and a strong odor of alcoholic beverage emitting from her breath. The defendant admitted to consuming alcohol prior to driving. Officer observed the defendant to lose her balance when stepping out. The defendant also appeared disoriented. Officer could not perform SFSTs because the defendant avoided following the stimulus during HGN and became aggressive during the walking through the instruction phase. DIC was read and refused. Blood search warrant was signed and executed. And while drawing the defendant's blood, the defendant became physically aggressive and used her right leg to kick officer's left kneecap, causing pain.
So that's the felony assault then,
Yeah,
the kicking the knee.
exactly. It was a reaction to something.
Ma'am, I'm going to find that there's probable cause to go forward with your case because you had one recently dismissed. I'm now placing an additional restriction on you. You're not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will put you in jail. No more PR bonds. Do you understand? We send notice to DPS in Austin so that every police officer in this state knows if you're caught driving a vehicle and vehicle doesn't have an interlock, they're going to take you to jail. So just don't drive one without a vehicle. Also, no alcohol, no illegal drugs, including marijuana. You will be tested. If you test positive, then likewise, it's just not going to go well. You've got a lawyer because you have one. I will waive your appearance. It is your responsibility to stay in touch with Mr. Burns. If he tells me he cannot get a hold of you, then you know what's going to happen. I'm not asking much. You understand? Okay. We'll have you sign a reset. You'll get the bond for your bond conditions. Then you're free to go.
Thank you.
Thanks. Great to see you. Have fun.
That's it.
Hi. Are you ready?
Yes, Judge.
That's it?
Yes, Judge.
Wow. Fantastic.
Excuse me, I'm approaching on Miss Brown. She's in custody. She's at the bail hearing today.
Okay.
This is a 2020 theft case where she had a habeas filed as bonds raised $2,000. We're asking for her PR bond to be reinstated. If you would like to honor out.
Deputy, do you mind bringing out Miss Brown, please?
The horse that was trying to sit on.
I got it. Donnelly, do you have an arraignment?
Yes, sir.
Okay.
What's the last name?
Barry?
Oh, Papa, one judge?
I guess let me do this real quick and then we'll just have him stand right there. All right, you ready? Do
Yes, sir.
you mind bringing up your?
Sure. Want to?
All right, good morning, sir. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On April 30th in Harris County, officer observed a motor vehicle with no front license plate, swerved within its lane several times, and also found it to have expired registration. A traffic stop was conducted. The defendant, the driver, had glossy bloodshot eyes. Eyes also appeared to be drooped and seemed dazed and confused, slow to react, and slurred speech. Upon exiting, the officer observed a circular sway, and the defendant admitted to drinking and rated his intoxication level as a 2 out of 10. SFSTs were conducted, 6 out of 6 HGN, 5 out of 8 walking turn, and 3 out of 4 one-leg stand. The DIC was read, and the defendant consented to a blood draw.
Any prior DWIs?
No, Judge.
License?
Eligible.
All right, Mr. Barragan, I'm going to find that there's probable cause to go forward with your case. As a condition, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, I will revoke your bond. You understand? Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Smith. You're not allowed to drive unless you have a valid license. You must also maintain liability insurance. Do you understand? All right, we're going to have you sign a reset. You'll get with Veronica for your bond conditions, and after that, you'll be free to go. Take care.
Thank you.
Please. Thank you, Donnelly. Good to see you, man. Okay, please.
This is Miss Brown.
Good morning, Ms. Brown. How's jail? You enjoying yourself?
No.
You know, the funny thing is it would literally cost about $100 just to get you out of jail. Maybe $101 just to get you out. You now know that if you go to jail, even at $100, there's no one to bond you out. So every time you miss court, what happens? No, you go to jail. When you've picked up a criminal case, there are certain things that you have a duty for, you have to come back to court. You can't just say out of sight, out of mind and just forget about it. The court system doesn't work like that. At some point, we will deem you a flight risk and then you're just never going to get out. Do you understand? Tell me about your client.
Yes, sir. So she is currently living with her sister and her brother-in-law. She's been living there since February. Part of the reason that she's not reappearing in court is that she did not have counsel and at the time was unstably housed, did not have transportation to attend court. But from living with her sister and her brother-in-law, she does have their vehicle and they'll be able to drive her to and from court. She has a cell phone as well for notifications as well as to keep in touch with me. And you currently working on, is that correct? She's also working part-time in Sonic, so she does have some financial ability to do the PTI for the state offers.
Where's the theft from?
It is from, the target, Judge.
What is your position on a PR bond for Ms. Brown?
Not this one.
Ms. Brown, I'm going to tell you now, if you ever take off on me again, I'm not going to do this again. Do you understand? But I mean, due to the age of your case, I can't just trust you now because you've blown us off for literally 5 years now. So I'm going to put a monitor on your ankle so I know where you are and you're not going to get forever. This case is. $2,255 days old. For perspective, we set cases for trial at 180 days. You have one opportunity to do something of value with this case. I'm going to give you a PR bond now. You're going to get a monitor on your ankle so we know where you are. And you have 30 days to figure out what you want to do with this case. At that time, you must be back here. You must either accept the plea bargain agreement or we set this case for trial. Do you have an offer on the case now?
Yes, Judge.
What, I mean,
It's PTI, Judge.
so,
And at that point.
so literally all you have to do, you're okay with keeping that?
Yes, Judge.
All you have to do is an anti-theft class and they will dismiss this case. A theft is about the worst possible thing you can get on your record because when you're branded a thief, no one hires you. You understand?
Yes.
30 days, that's it. Okay? All
Thank you, Judge.
right, good luck, Ms. Brown.
I'll speak to you. Okay.
Yeah, I don't, can we reinstate? Would it be easier to? Whatever's easier for everybody. Okay, yeah, do the PR bond. Carl, you ready? Come on. Yeah. I need stage. Right?
Yes.
Oh, Victor, I forgot about you. I'll hit you up next.
Okay, Judge, thank you.
Got BVR, Judge. Most of it has to do is.
Hands down.
Class. When our service, he was charged.
Is it still dead now?
No, he's got it charged.
Deputy, I need your help. I'm sorry, man. It's a second bond violation and he's out at 4 a.m. You know, that's exactly what we asked him not to do. I'm sorry, Mr. Ratliff. You can't just continue to pick up violations and expect good things to happen. It goes with you. Sorry, Carl, but.
Okay.
5,000, please. Hey, you ready?
Yes, Judge. And motion and a blood discovery order that should be in your meeting, Judge.
Say, what is it?
A blood discovery. order.
I'll sign it.
Okay,
I'll sign
thank you, Judge.
Yes.
it. Mr. Stevens,
I was waiting on you, Judge.
got it. All right. Victor, you ready?
Good morning, Judge. How are you?
Give me 1 second, buddy. 1 second. What is the last name of your client?
Washington, Judge.
That's right.
Okay, got it.
And Judge, I've been trying to email, or I emailed and I contacted ADA. I'm sorry, I don't know how to say her last name. Nakvi, I believe is her last name. The CW is continuously trying to get a hold of the state to try to give them a RIP statement. Essentially, she's called me 2 or 3 times this morning already. I've already spoken to her. I gave her Miss Nakvi's phone number, and she contacted Miss Nakvi via text message. But she's waiting for a phone call still.
Is Washington your case?
Yes, it is. I mean, the scenes of calls from her after I had already left.
Okay.
I haven't had a chance to meet others. And we don't have a 911 call in yet, so I haven't been able to do it. Yes, actually, I haven't been able to do a full eval without everything in.
Do you want an eval, Victor? Is that what you want?
Well, yeah, Judge, and I'd like to approach you also on the bond condition itself of having the portable breath device, Judge. The DIMS summary, the offense report, the videos, the body cam videos, none of them support the statement that there was any alcohol involved in this situation, Judge. In fact, the video is contrary to that. The video shows that.
Well, look, I mean, I can't get into that now. I mean, that's.
I'm speaking mainly just for bond conditions, Judge. I don't believe he should have a portable device. My understanding is that you put the portable device because
Washington, come up.
my understanding is that you put the portable device because there was a note by the officer saying that they had been drinking all day. That the video does not show that. The video shows him telling the officer that the drinking happened 2 days before. And so I don't believe the portable device is appropriate in this case, Your Honor. Additionally, Judge, we were there, or he was there on Tuesday, May the 5th. As you know, I couldn't make it to court, so I asked the coordinator to roll it to Wednesday. Mr. Washington did go take a drug test on Tuesday, which I'm assuming came back negative since we haven't heard anything about it. So he's following your bond conditions with respect to that, Your Honor.
Baloney, he's following the bond conditions. We now have do you remember what you told me last time we were here, Victor? Do you remember what you told me? You said, there's going to be no more bond violations. If he has any more violations, you know what I mean?
I didn't tell you that. I don't ever tell you that, Judge. I think that's what you said. I think
a bond violation again.
And Your Honor,
excuse, Mr. Washington. You know, when my child says sorry to me, I said, okay, bud, really, it's fine. Just please do better. Dad, I'm sorry. Again, second time, but I told you, please, come on. I've told you once, I've told you twice, and then a third time. What does the value of that sorry mean, Mr. Washington? Stop. It means it goes in this ear and it goes out that ear. It does, because it means that you don't respect the bond.
Your Honor, if I may, Judge.
We have 16 skip tests.
Those are when I'm asleep. Like when I'm asleep, I try to wake up to take the tests. Those are only around the times when I'm asleep. But I'm telling you, I assure you, I'm not drinking anything like that.
Your Honor, if I may, Judge.
I know.
I understand we had this conversation.
And this is now a second, a potential third. I discounted the first one. You had a second, and I told you it was absolute no tolerance.
I'm definitely taking your conditions to heart, sir.
I don't believe you.
Yes, I am.
Hey, deputy. Sorry, Vic.
Well, Your Honor,
The third,
again,
it's a second violation, and he's got 16 skip tests.
Your
If
Honor,
I let you go now, what does that say, Mr. Washington?
That you trust me to do better.
It says that it's okay for you to continue to have violations.
I'm literally not drinking. I literally be sleep. I have to work to get to pay for my bills and stuff like that. When I'm asleep, I try to wake up to take the test.
Stop. I cannot continue to enable.
I
And at
just need
some
to-
point, that's it. You're now working number 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12.
Sometimes
And
the
now-
machine also malfunctions as well. Like when I tried to blow, it would malfunction to where I couldn't even blow in at the right time. So, I mean, all of it is not all my fault.
Whoa. Then if there's ever an issue, then you come to court. Had I not hauled your butt in here, we'd be doing the same thing over and over and over. It goes with you.
Your Honor, again, if I don't believe the bond conditions, I don't believe the interlock or breath test device should be as part of his bond conditions, Judge. There's no alcohol involved in this situation.
Okay, so come and talk to me, but
I did.
you don't come.
I did come and talk to you, Judge. You, for lack of a better term, you blew me off the way that you just did Mr. Washington right now,
That's
Judge.
nice, Vic. That's nice.
The report,
I mean, yeah.
Your Honor, every time I've come and talked to you about this case, Your Honor never wants to address the situation with me. You always want whatever reports that the CLO has or the pretrial officer has, Judge. And so in this report that we received, although it claims that there's 16 tests, this isn't to justify or make it better. There's only 9 skip tests on the report that was sent. So it's not 16 skip tests as far as the report that was sent to me, Judge. And again, I don't believe that that breath test monitor is appropriate in this case. There's no alcohol involved in this case. Had the state been able to do their evaluation, I believe the case would have been dismissed today, Your Honor. The evidence is completely insufficient to support.
And they're free to do the eval now, and if the state's free to do whatever they want.
Can
We
the
put
state
bond
make
conditions on.
contact
It's
with the
not hard to
CW?
live up to it, really.
I'm not saying that it is hard to live up to it, Your Honor.
Victor, I'm revoking his bond. It just continues to happen. I'm sorry.
Well, again, Judge, it didn't continue to happen. This was the first one was because there was a mix-up between the documents that was given to him in court and the phone call or the message that he received from pretrial services. If you remember, Judge, I came forward to you and I showed you the phone conversation from pretrial, which showed the text message saying, "You don't have to come in today." So he didn't go in today, but your paperwork that you gave him upon release showed that he had to be there for a test on a certain day. That was the whole mix-up. Your Honor didn't accept that explanation, even though I showed you the conversation, the text messages.
I
showing
did,
that they
and I
told-
didn't put him in jail because of it, Victor. What are you talking about?
That's why you put him in custody, Your Honor. And then you had him go get drug tested. And then after
I
that,
did not revoke his bond on the first time there was a violation, did I?
I don't think I was even on the case on the first violation, Your Honor.
You came in, yes, you were. You came in off docket trying to get me to commit to not revoking his bond because it wasn't a true violation because he never got the text or he never got the phone call, and then said, okay, I'm not going to, and I didn't. And now we had another bond violation, and now we have another bond violation. I'm revoking his bond, Victor. That's it.
Well, again, Judge,
I don't want to argue with you, man.
I'm not arguing with you, Judge, but this is the only way I can communicate with the state as well, because they don't respond to my text message or my emails. So I'd like for them if they could please call the CW right now. The CW is waiting by her phone. She's texting me
So
5
look,
times just
what
today.
I'll do is I will have the state, as soon as we die down a little, I'll have them go out to try to reach out to her. Regardless, the 911 is not in. I don't know what's going to happen and whether they're prepared to do an offer, if that's in or not. I don't know.
And Your Honor, we tried to reach out to the complainant prior to today, and she was not answering her phone.
Did you hear that?
I can show you text messages and phone calls saying that the CW herself has reached out to the state.
Okay, yes, you're correct, but she had reached out to Farwell after Farwell had left yesterday. So she's now,
And
when
she's
it
reached
dies
out this
down,
morning as well, Judge, just so everybody
she's
understands.
saying
what's
that she's never gotten anything.
I received text last night, or yesterday evening after I left the office. I got into the office today and started talking this morning.
Okay, I mean, if there's a way that the phone call can be made, and if Your Honor would hold on sending them all the way down to be processed, if the state is willing to make a decision today.
I'm gonna revoke his bond unless they're prepared to do something with it, Victor,
That's
but
what I'm asking.
I'm not
That's
gonna reinstate. I mean,
I'm
it's just,
not asking you to reinstate, Judge. All I'm asking is to hold him there until the
Sure.
state makes a decision.
yeah, I absolutely, I'm happy to hold him until the end of docket. At that point, we'll see what transpires, I guess. Can you do a writ?
I can actually. Sure.
Go for it. All right, they're going out now.
Thank you, Judge. I'll stand down, and I'll stay on Zoom just to see what the response is, Judge.
Counsel, are you ready?
Oh, yeah.
Come on. Just the last name of your client.
It's off docket. Probation.
Okay, I'm ready when you're. Oh. Is it Umana?
Yes, sir.
Umana, come up. Around. You are Mr. Umana.
Yes, sir.
Sir, you're charged with driving while intoxicated. Is this a second offense?
It's for dispatch.
There's a previous one from 2016, Judge.
Right. All right. So, Mr. Umana, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. The state has elected to reduce it to a first DWI. However, you need to understand in the eyes of the law, it is still a second offense. What happens next time? Up to 10 years in prison. And let me tell you, Mr. Umana, your record is not pretty at all. Every time you get pulled over, what are officers going to do? Every time, if you have the smell of alcohol, you have the smell of anything funky, it's probably not going to go well for you. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. This now will reflect as a conviction and it will be there for the rest of your life. You understand? Is this what you want to do? How do you plead to this offense? Guilty or not guilty? The agreement that you have worked out is a 180-day Harris County jail sentence. However, to be probated for 2 years. As part of this agreement, you will do a repeat offender DWI education class, 1 victim impact panel. No drugs, no alcohol, random testing. You must maintain a guardian interlock and 24 hours of community service. Do you understand?
Yes, sir. Currently has affordable. I think that we aren't driving right now.
Yeah, and I was going to suspend the license for a year because it's a second. I'm going to suspend your license for a year. You will be signing an affidavit with us today promising us that you're not going to drive, Mr. Umana. If you do something to violate this probation, I will issue a warrant for your arrest. I will put you in jail. I will make your bond relatively high. And then we're going to bring you back out in Orange and we will have a hearing to determine if you violated this agreement. If you do, you were looking at 180 days in jail. If you failed to go to probation, if you failed to do your classes on time, if you test positive for drugs or alcohol, if you don't maintain the portable device, all these things will cause a warrant to issue. Do you understand? Do you have any questions?
Okay.
How do you plead to this offense? Guilty or not guilty? I'm going to find you guilty. I'm going to follow this agreement, sentence you to it. Look to you, sir.
Alright. So first he has an ankle down wrong, and I think maybe he got a felony.
Oh, he has a felony case too?
It was dismissed, but he still has one of them.
Was the felony dismissed because he's pleading to this case? Not many times in life that they're going to dismiss a felony in exchange for your plea on a misdemeanor. It's a lucky break. It's not something that you get over and over and over. Do you understand, sir?
Sure.
Okay, so does he have a portable device now?
Yes, he's a portable device. Did you bring it with you? Okay.
Okay, if once we can confirm that he has it and that it's operational, yeah, we'll take it off.
Are we waiting the details to confirm that?
No,
I'm appointed, I don't believe he's,
we will give him time to pay. But what I do is you're now going to get hit with a $3,000 surcharge. If you don't pay it, every $100 that you owe, you will sit 1 day in jail. Do you understand? So you could be potentially sitting a long time in jail. This is to get you to understand it's unacceptable and we need to, at some point, get your attention. You're skirting days in jail that you should be doing mandatory on the DWS second because they've reduced it to a first. You understand? All right, good luck.
okay.
So waive the fees. So what we do is we waive the probation fees
Yes,
and just hit him with the 3,000 so he doesn't kind of pay duplicate. He's going to pay it regardless, whether it's supervisory fees or whether it's through us and to the court. So we waive those fees. We'll hit him with this so that if he starts to play around, then he's doing some serious jail
a
time.
monthly contribution to your DPS probably is about what your probation fees would be, so.
Right.
Where would do that? Anyways, I guess the other thing is his suspension, concurrent with any prior or suspension.
No, what? It's a DWS second, man. What? You want a back rub too? No. You need to feel the pang of a suspension. Don't drive. Do you understand? Good luck.
What's included with the 2000 check?
Yeah. I know you. Hey, what's up?
Bring back ropes.
Deputy, what's the guy's name again?
My phone,
Yeah.
and the guy with the background, I don't have nobody, none of those.
Oh, you don't have? Okay.
I'm clean.
Tell me.
Okay, we're with a trial case on Monday.
Yeah, are you ready?
On Monday, yes.
We're going.
We're ready.
Yeah. We'll get a panel at noon and then you're up. So we'll go. Yeah. Oh, wait. Anything you guys disagree on? Shut the front door. Moses, hold the roses. Okay, great. Okay. See you Monday. Ready?
Morning, Judge.
Hi, Jerome. How are you, man?
Judge, I'm approaching on Mr. Darren Ford. I'll give you a minute to pull him up.
Okay.
So, Mr. Ford was on probation for assault, picked up a possession of marijuana. This past Wednesday, you sent him for a UA. Because our intention was to get him back onto his probation. He was positive, from what I'm understanding from
He
probation.
never stopped.
Um,
How old is this case now?
And I'll tell you now, we'd like to get him back on that probation. He's,
So here's the deal. He picked up the weed case April 24th, right?
yes, sir.
We told him not to use, let's see, I'm not going to continue to play this game. So, I mean,
Can I say this, Judge? He's got four and a half months left on probation. And so he's telling me that in that his probation officer has recommended SOP, which he can get in right away. And he's gonna get into his BIP classes. He found a $90 class and he can get all of that done. But well before September when it expires. The car he was driving was pulled over because the registration was out. He's got the registration, got the insurance. He's trying to.
but
put
he's
himself back together.
smoked weed the entire time and he has not stopped smoking weed.
There appears to be a problem.
The one indisputable fact is that he cannot stop. Mr. Ford, come up.
There appears to be a problem, going back to December 2024. I mean, it's like every few months we test positive.
What on earth do we need to do to get it to stop? Stop. It's a rhetorical question, Mr. Ford. One that can only be alleviated one way, if you catch my drift. I ordered you to stop using at the time that you picked up this weed case. And I want to know that he tests negative. So we usually give people about 50 days from the day that we tell them to stop. And so that's what we'll do. We'll test at the 50-day mark again. If you test positive, it's just not going to go well. You're giving you one final opportunity. Keep everything going now, but I'm testing at the 50th day from the day he picked up this weed case and we told him to stop using. You better be negative on that day.
That's fair, Judge, and he would also get enrolled in SOP and his first class.
You better get on it, doggone it. And baloney. Test negative the next time. Do you understand? Okay. So let's do the 50th day, whatever that day is, and we'll do a POC test on that day.
Yes, sir.
Okay.
I'll be here on that day.
Cool. All right. Up here. Yes.
I'm just currently not being supervised for a pre-trial on my drug.
Do it. Yeah. Okay.
Judge, I do have one other matter.
Okay.
Susanna Saldana. She's not on docket today, but I think Victoria might have sent you an email regarding Ms. Saldana. And let me get you a file number. I apologize. And this is a bond condition issue.
Okay.
So that cause number, Judge, is 261.
Hold on. Let me write this down before I forget. 200. Okay, I'm ready. 261. Yeah.
2457. So Ms. Saldana,
Does she not have bond violation?
no bond violation. No,
Okay.
sir. It was a bond condition issue. Judge, you put her on a curfew. Her job, I think you put on a curfew that was from 8 PM until 8 AM the next day, something like that. Her job, she works from 5 PM to 10 PM.
Give me, you have proof?
Hopefully Victoria had time to send you the email,
Yes.
because you asked for proof. You asked for something on letterhead from one of her superiors stating that her hours were.
How? Okay, I see it.
And so Judge, she cleans offices over at NRG Park. That's from 5 PM till 10 PM every night. She takes the bus home. She gets home around 12 midnight. She says that she can safely be home at 12 midnight.
This doesn't say the time though. It just says that she works part-time.
Right. I got you. Those are her hours. They have to be done. The cleaning has to be.
Show me the hours and then I'll acquiesce to you.
The hours.
But yeah, I want to see it. I'm not going to take her word for it.
I
But
got
yeah, show me and then I'll do it for you. She should have some kind of work schedule somewhere.
I agree. We've
Get
been
it,
working
and
on
then
that back and forth for the last. few
show me.
days. I'll get that.
Please.
Thank you,
Okay.
Judge.
Yeah.
I appreciate it.
Hi, Ron.
How are you?
Hey, what's up?
I have Ruiz on docket.
Okay. Is it an arraignment?
Yes, sir. It's BWI second,
Ruiz, come up.
the fail to maintain single lane. When it comes to. I think the first BWI was like 03 or something like that. Yes.
All right. Good morning, Cherise. You're charged with driving while intoxicated. Second offense, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, ma'am. Okay.
On May 3rd in Harris County, officer observed a vehicle fail to maintain a single lane with other motorists on the roadway and failed to signal a lane change on I-45. Traffic stop was conducted. The defendant was identified as the driver. SFSTs were conducted 6 out of 6 HPN, 7 out of 8 walk and turn, and 3 out of 4 will leg stand. DIC was read, defendant provided a breath sample, 0.172, 0.179.
She have a license to drive.
She does, Judge, it's eligible.
Okay. Ms. Ruiz, I'm going to find that there's probable cause to go forward with your case. Because this is a second offense, I'm ordering you not to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, your bond will be revoked. You will go into custody. You understand? Do not pick up any new cases. Do not consume alcohol or illegal drugs. Those are also your bond conditions. I don't care that what kind of party you go to, just don't use. I'm not asking for much. Do you understand? Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them. If they tell me they can't get a hold of you, then likewise, I will revoke the bond. I mean, you see how many people go in. We're not asking for much. Do you understand? Okay, we'll have you sign a reset. You'll get with Veronica for your bond conditions, and after that, you're free to go.
Thank you, Judge. Have
Thanks.
excuse?
Got it.
Thank you.
Have fun. Hi, Armin.
Good morning, Judge.
Great to see you, man.
Great to see you.
How are things?
Things are well.
Haven't seen you in a while. Are you still around here? Are you going everywhere?
Just, stopped taking appointments a while back, so it's just,
Business is good.
it's.
When you fight, you know,
So, no, I'm alive, so just not being told.
the running around is, it's a lot. You know, and then especially if you have a lot of people that drag. Yeah.
That's the whole campaign, go
Say, a couple months,
day by day.
day by day, right? Who's your guy?
I have Miss Osorio.
Is she here?
She is,
Okay. Osorio, come up. It is that she failed to take a test, right?
Judge, yeah.
She took one this morning and she came back with it.
Wonderful.
And she's had 2 other negatives and she went the day after.
You're good.
She was scheduled,
Okay.
so,
We'll just give you a receipt.
yeah.
Okay.
Thank you, Judge. She's already been approved for PTI. The TRS is
Okay.
scheduled for end of.
Sooner you get done, sooner you get done, you know? Okay.
Yeah, sorry, she meant it was, life
It is what it
happens
is.
sometimes. Yeah.
Have fun, man.
Is she free to leave?
We'll wait and get a reset.
Okay. I just
Did you get that rip done?
Yes. I just found the dismissal on it. Yours. Washington.
It's being, you're dismissing it?
Yes, I found it.
ready for
Got
you.
it. Okay, they're gonna dismiss it, Victor.
Thank you, Judge.
Let him go.
Thank you, Judge.
Once I sign it, then I'll tell the deputies, let him go.
Okay, I appreciate it. Have a good weekend, Judge.
Okay, have fun, man.
Thanks, you too.
Take care.
Bye.
We received this email about the, there's a warrant with the mower-ups, and it just wants judges to make a notation on the mower-ups. If they're going to be 61 days or 91 days. That's just kind of more reference. to
Can we
here.
do the 121?
It says with a deadly weapon, I'm not sure if it was with a deadly weapon. I don't think it was.
No.
It's,
Oh, I don't know. Well, I don't know. Serious violation when you throw a leech on a baby.
no, this is Mr. Coble. This is Mr.
Oh, okay.
You're talking about Mr. Coble.
Got it. Okay.
This is the one with the wife. It's on the warriors.
Where do you want me to put it?
I guess you could write there,
Because it has it,
right
right?
here. Right, and it means, just as long as it has a notation from you, so you can get verification. Yes, that's good. You're good touch.
Oh, hold on. Let me see. Let's see. I don't need to sign it back or anything.
No, the rest is Spanish.
Okay.
Yeah, thank you.
Oh, Sir, you ready?
May I approach, Your Honor?
Please.
Good morning, Your Honor.
Hey, good morning.
I'm approaching on Mr. Cobble, appointed to this case here today.
Okay.
I believe the state has given the courts the correct information. Misdemeanor is part of the felony. Virginia said they had filed, and they are filing a motion to dismiss the.
Oh, really? Got it. Okay. Hey, so they're going to dismiss Cobble and they're going to dismiss Washington. So as soon as I sign the nollies at that point, they're
I've already filed the dismissal.
on both of them?
On call.
Should we still do the law, Judge?
No. I mean,
I believe there's one in place on the felony. He has already posted it on.
I'll say it.
There is one in the phone.
okay, yeah, no, they're going to dismiss it.
Thank you.
Okay, thanks.
Thanks, sir.
No problem.
Thanks.
Thank you.
Right, Judge Cobble and Washington.
Yeah, they're going to get, both of them get dismissed. Do you have any? Yeah, yeah, yeah. Do you have any more PHAs or anything like that?
THA, we had a couple of arraignments waiting on the attorneys.
It's ready now.
Speaking of.
Ask.
Judge, I'm Mr. Dustin Shepherd on docket today.
Oh, I forgot about you, Kavita. I'm so sorry. Next time yell. I always forget. Let
It's
me
okay.
talk to Abel real quick. You said,
Sure.
what's the name?
Shepherd, Dustin Shepherd.
Okay.
So he was in Montgomery County, Judge. Apparently he was brought back and made a PR bond of some sort. He was set for yesterday.
Yeah.
As well as today, a bond forfeiture. But I figured it all out between yesterday and today. So I'm requesting if the court will give me a 2-week reset so that I can mail him a letter to the address.
I'm not going to do 2 weeks, but I'll do a week.
Okay, next week. Okay.
Yeah. So well, let's do exactly a week from today. We'll set it for bond forfeiture.
Perfect.
Hey, on
Shepherd.
we'll set it for bond forfeiture for 1 week. He got a PR bond failed to appear yesterday. So okay, Kavita.
Yes, Judge. I have Crystal Rodriguez on your docket. She was in custody, but somehow got released between yesterday and today when her felony case was dismissed. She does have a bond violation for the new felony, and she's not there this morning when I came in.
Yeah, she's not here now. She got a bond violation again.
Do you want to roll it until Monday?
Crystal Rodriguez. Can you do me a solid? Can you out there yell for Crystal Rodriguez just to see if she's out there, please?
And
So
I went to the jail yesterday and met with her. So she probably got released and without a means to get to court. She probably didn't make it. And I don't have a good contact number for her, but
wait, I thought you said you talked to her yesterday.
I did when she was in custody. And then,
I mean, if she's not here, I'll end up revoking it, you know?
okay,
So
that's fine, Judge.
I guess just, I mean, go so you don't have to wait. If she ends up coming, I'll reach out to you.
Okay, sounds good. Thank you, Judge.
Thanks. 5,002 is in next.
Question. That's on this baby's place. She came by yesterday. And
She asked for Friday.
Yeah, she submitted everything she was supposed to submit.
Great.
She's waiting on.
Usually about a week it's really old and we're just. What's the last name?
Smith, Aspen.
No, okay, thanks.
Page 18.
Hey, guys, can you verify on Smith that everything's been turned in for a PTI, please?
He was approved. It was approved.
Oh, it's approved. Great. Is she here? Is he here? Okay, it's already approved. So why don't we, are you talking to her now?
I called her and tell her that he's been approved. And how long of the
No,
recess?
come pick a day next week. They gotta come this week and do a two.
Okay.
Yeah, any day next week, but they gotta be here next week.
Yes, sir.
Those two can go. They've been dismissed. I don't know if you let them go already. or not. You did? Okay. Hey. You just want to do it anyways? How many more do you have? Arraignments?
We had another turn attached already. The status attorney was attached back in 2025.
Do we know if she knows about it?
Usually they don't.
Yeah, I guess so. Yeah.
Page 3, Caesar. Come on up.
No, up here, right there. Great state of Texas. I might need your help here too. Mr. Caesar, you have picked up yet another case. You now stand charged with criminal mischief number 2. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On December 10th, 2025, the manager at Domino's in Harris County, Texas, advised that he observed defendant behind a counter where only employees are allowed, who then asked for food. Complainant denied. Defendant pushed him, grabbed a box of breadsticks, which complainant was able to recover. Defendant then opened the door in an aggressive manner, causing about $1,500 in damages to the front door catch. Officer received video from Domino's showing defendant and complainant arguing, defendant walking towards the door and forcefully pulling it backwards, causing damage.
The first criminal mischief, what happened on that one, if you don't mind?
Officer was dispatched to a criminal mischief call. Complainant advised defendant approached him and asked for money for food. Defendant became upset and placed a handful of rock and picked up a handful of rocks and threw them at complainant's vehicle, damaging 3 windows and denting the driver door. And Your Honor, that occurred at a McDonald's.
What did I
Oh,
tell
I'm
you
sorry.
the first time you were here? Mr. Caesar, stop. No, I told you that this is not a revolving door. You were on bond for criminal mischief. You've picked up another criminal mischief, and they've given you a third PR bond. Hell no, goes with you. No more PR bonds.
Can I say one thing?
No, I will appoint you a lawyer. Stop. I will appoint you a lawyer and you can tell the lawyer, but this is not a revolving door.
I didn't
Goes
get
with you.
arrested, I didn't get arrested that case is an old case. That case is an old case.
And you were still on bond for it.
No, I never was on bond. I never received the bond for that case, Judge. I promise. I never was arrested for that case, and so I already had the second case. Look at it, Judge.
Hey, I need you to file bond conditions. No going, you know what? Should we do a monitor?
I believe we should do a monitor.
All right.
Cases in pretty quick discussion.
Let's do this. Let me get him a lawyer and then we'll discuss it, but certainly no weapons, no going back to, no drugs, no alcohol, no weapons, no going back to the Domino's, no going back to the McDonald's, no contact with the complaining witness, no weapon, no rocks. What else? Is there anything else? No possession of rocks? Carl, ready?
Prior to this approach, you began to together all of the state of 60 minutes. I don't want to be inclined to the something. I'll be back to my and John, he's one that always set up deferred and non-conditional. What happens? Continue to have the contact.
But if he couldn't even keep up with just the bond, I get it, I understand, but he couldn't even keep up with the bond conditions while on bond. How's he gonna make probation?
This is the only violation he's had for him
Since December.
since last time. I mean, he's been doing well since then. He's been abiding by everything. He just is advised went out of power.
What do you think?
I haven't had too much of a chance to see this one, Your Honor.
Only thing I want to know is whether or not if you were willing to accept the plea.
I am.
Come back Monday.
No. But my only concern is that if he can't keep it straight on bond, how is he going to keep it straight for the next 7 months? That's the only, because
Basically, abided by the bond conditions, since he's been on bond, because he hasn't had contact with the.
well, that's one part, right?
The only one condition that Mr. the prosecutor required that he continue not having contact for the next 6 months.
Hey, the felony assault that he had, is it the same complaining witness as this one?
I don't think so. The complaint in this case is murder.
Oh, hold on. Ms. Jones, are you here on Caesar?
Yes, I am.
Can you talk to Victoria real quick? I don't know if she took your offer or not, just because we didn't know whether you knew about it or not, because it's so old. Okay.
There's a different complaint.
Yes, Your Honor.
I'm okay with it. I mean, if you're okay with it, then I'm okay with it, but just
I'm sure. We'll have a talk.
let them know.
You'll have a talk.
Council for recess. Yes, 7:30.
Yeah, just let him know. Yeah, just let him know. But he can't leave. Yeah, okay. Yeah.
Right.
Yeah.
Yeah, I do know about it.
Yeah. You say, yeah, for sure. Hey, ixnay on the PR bond A. Any more arraignments? Is that it? What's up? Hey, I'm legitimate. Is Mr. Floyd here?
Yes, Judge. That is turning plan on
Oh, and it. Thanks.
Keep you on until you tell me.
Yeah. I know, I'm okay with that. One day I'll show up. One day I'm gonna come, I swear. I just, hey, great state of Texas. I need you again. Zachary Floyd, come up.
Cooper?
Mr. Floyd, you were placed on probation in 2012. We are now in 2025. You are facing up to 6 months in jail and or a $2,000 fine. Has Mr. Floyd picked up any other cases while he's been out?
Running his residency right now.
Please, that'd be great. Does he have a license to drive?
Running his license as well.
Did Mr. Floyd do anything?
Judge, it looks like he completed all of his classes. It looks like he fell to a board for 2 months and then a martial issue, monthly fees. And, his advice was in lockout also because of fees.
What have you been doing for the last 15 years, Mr. Floyd? You're just because you don't have an idea, your life falls apart, Mr. Floyd?
Well, I mean, I didn't really important that he is get a bank account, he is some volleyball games.
Have you been living on the street this whole time? Where are you living now? Shh.
He hasn't picked up any new cases, Your Honor, and his driver's license is currently not eligible.
Well, let's do this. Do you mind appointing Mr. Floyd a lawyer today? Does he have anything left else to do?
No, Judge, he completed all his classes and programs.
Okay, we'll just unsat term him.
Okay.
Okay. We're going to kill your probation today. Don't pick up any new cases. We're not asking much. You need to see how many people go to jail in and out, really. All we want, our streets safe. We're not asking for much. Do you understand? Okay, man. Good luck. We'll waive all the fees. You won't know anything. You're free to go. Okay? Just be careful, man. All right? Okay. Yeah. Hi, Adam.
I have been called.
Do you, hold on, Adam. Do you need him for anything else? Okay, I'm sorry.
Yes, I have,
In jail?
Yes.
Oh, right.
Yes.
Can you bring out Mr. Baldwin, please? Baldwin. Do you mind bringing him out, please? Your fault.
Which I do want to notice before he comes out, the attorney in the felony case has actually filed a suggestion of incompetency.
Oh, really?
Yes.
Have you communicated with him?
I have, not very much, but I have.
Are you able to communicate with him, I guess, is the better question.
I feel that I am.
Okay. Well, sometimes it happens as a matter of course, an abundance of caution, you know?
Yes.
And then I would say a lot of it also depends on how soon they got picked up. Are they under the influence of something at the time that they, are they still, so. Veronica, on Mr. Baldwin, did we put the GPS monitor on him? We did?
And so we called him to tell him that the receiver was never in the reports to our office, so then they answered the phone and said the chief's gonna pick him up and bring him in. But he never reported in wrestling for all of the, we had no GPS signal.
You know, we do everything in our power to try to keep you out of trouble, Mr. Baldwin. Put a monitor, try to give you a curfew, and now you damn picked up 2 serious felonies. You are, in our criminal mischief here, have any relation to the burglary of a habitation or the other criminal mischief?
Yes, Your Honor, our criminal mischief is from the same transaction as the burglary and the bounty criminal mischief.
You know, I find that there are no non-financial conditions that will suffice to protect our community from you, Mr. Baldwin. You're complete and you're just a danger. I'm now going to match your felony bonds and I'm going to set it at $50,000 as well, 50,003. If you do bond out, you will be ordered to be under house confinement. You're not allowed to go anywhere unless it's a hospital or to meet here in court. Do you understand?
And Judge, if I could just briefly maybe deeper on that.
Sure.
So I have spoken to Mr. Baldwin's mother. She's great. You understand that if you were able to bond out, to be able to stay at her residence. So he would have a stable place to stay. He would have his mother to the future court dates. And additionally, Judge, the bonds would be, even if this bond were lower, his felony bonds are currently at $150,000 altogether. So there is a very significant amount of bond, which itself should be sufficient to ensure future court appearances and prevent future crimes. So Judge, I would ask that you set a bond at a lower amount, perhaps something closer to the $5,000 that it was set at prior to considering.
He's charged on a first case with a second degree up to 20 years on the mischief of $150,000 to $300,000. On bond for that case, you pick up a criminal mischief with our case. We put a boatload of bond conditions on you. You picked up a burglary of a habitation and another felony on top of that. And it's all the same complaining witness.
Your Honor, I'm sorry, I misspoke. The first felony, criminal mischief is different from complaining witness.
No. Cute. But I was really considering even higher than that. You are a clear and present danger to our community, Mr. And, you know, the thing about it is that we only have so many things that we can give someone to try to keep them out of trouble. And at some point, you are the master of your own domain and you were running to prison, Mr. Baldwin, running. There's always someone bigger. There's always someone badder. There's always someone looking to make you someone. You know, prison is not a fun place and you are running to it. I don't think there's anything that will, I've exhausted every resource I have to keep you out of trouble and just, no, I think that bond is appropriate at 50,003. If you do bond out, if I find that you get out and you break these conditions, I have made bonds in the millions before, and I'm not going to lose sleep over it. Do you understand, Mr. Baldwin? All I want are my streets safe, and I'm going to do everything in my power to protect it. Okay, goes with you.
That's all I have to say.
Thank you, Mr.
Hello, Judge.
Hey, Jesse, how are you, man?
You're right.
Yeah. Marco.
Well, I think, yeah.
Yes, Judge, can you hear me?
Yeah, I got you. What's up, man?
I don't know if my guy's there, Guillen, he's not answering me. Did he make court today?
What's the last name?
Guillen, it's on the bond issues.
No, he no home.
Okay, if he shows up, I guess, Victoria, let me know, otherwise, I don't.
I'll let you know if he shows, man.
If not, what do you want to do with him, Judge? You want to put him
I'm
next
gonna
week?
revoke it. He got bond violations, right?
Yes, he does.
No. He gets revoked. It's a third bond violation.
Okay, I spoke with him yesterday and told me he had to be there, so I don't know if he just
No,
decided what wasn't a good idea, I don't know.
I'll let you know though, man.
Thank you, Judge.
Reach out to you, okay?
Okay,
Okay.
bye.
If he's a no-show, 10,002.
Yes. Okay, that is it. Sorry. Brandon, the sorry.
Hey, what's up?
Hey,
Happy Friday.
Mr. Osorio on docket today. Well, yesterday, he was not here, as part of parents. I called his mom, left a message. With mom, that's the only number I have. Relayed a message, she was here.
What's the last name again?
Osorio. He was offered a 90-day PTI.
Wow, it's like you get to beg people to work the dismissals.
Yeah, I mean,
you know?
So I don't know what you want to do today.
Well, no, I'm gonna revoke it if he's not here.
Okay.
Is she, why is it not showing up here? That's weird. I don't know why it's not showing, but anyways, regardless, yeah, if he's,
Should be a lot.
no, I see it, but I just don't see it on my doc because I can write it down. Okay, so, I guess I'm gonna end up revoking it if he's not here,
Okay.
you know,
I'm
and then,
not sure we're doing.
okay,
That's okay. I'll be here.
I got you, man. Are you ready, counsel? Please.
Sullivan.
So on the Osorio, it's 1,300 just lost. Okay. All right, good morning, Mr. Sullivan. Sir, you're charged with criminal trespass. Is it just one?
It is rough.
You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement. They're offering you 18 days in jail with credit for the 6 days that you've done. You need to understand something important, that this charge will now reflect as a conviction on your record. You will now be facing a minimum of 30 days in jail for any new cases that you pick up. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you plead guilty, it will go on your record. You can never take it off. Is this what you want to do? How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty. I will follow this agreement, sentence you to it. and good luck to you, sir. Thanks. Take care. Was he appointed or retained? On the plea that we just made. Appointed, okay, good.
Please. Yes. Well, I. Sorry, I should have borrowed that from court.
You're good, man.
For anything.
Yeah, I'm ready when you are. Mr. Ratcliffe, is this a good idea? While you're on bond, you have one bond violation, then you pick up yet another bond violation. And now you want to be on paper for the next 6 months. Is this a good idea? You know, you can lie to me, but you can't, as they say, lie to yourself. I don't know you. You know you better than anyone else. And the problem is that when you get on probation, you're expected to do a lot of things, and it's expensive. You're expected to report once a month, no drugs, no alcohol, no weapons. Any classes you do that you're ordered to do, you have to do it on time. This isn't probation how Mr. Ratcliffe wants to do probation. It's probation how it's ordered to do it. And if you think that the way that you have been on bond is going to work the way that on probation, things will get a whole hell of a lot worse if you get on probation and it gets mucked up. Do you understand? Can you really make this probation? I'm a firm believer that everybody deserves a chance. And the nice thing about this is that this is a deferred adjudication. So if you complete this successfully, there's no conviction on your record, but you give up nearly every right known to man entering into this agreement. And if you do one thing wrong, you pick up a new case, don't report on time, test positive, we issue a warrant, your bond is going to go probably pretty high. You're going to go back to jail. And then we have a hearing. And then now you're looking at a year in jail. Do you understand?
Yes, sir.
Do you still want to do this? Is this a family member?
Yes, Your Honor.
There's an affirmative finding on this case, meaning that you can never own a gun or ammunition as a result of this plea bargain. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported. excluded from the country, denied naturalization, you give up the right to appeal. This is now a probation that you're entering into. Once you enter into this, you are stuck with this until you complete it successfully or it gets revoked. That means complete compliance. Do you understand? If you ever have any issues, you can come back, talk to us, we can work through things, but the worst possible thing you can do is either just take off, pick up a new case, or have any kind of contact with the complaining witness in this case. Do you understand? That means no weapons as well.
Sorry, the plea bargains with no written arrest. Contact.
Complaining witness is who? Mom?
Mom.
Does mom want contact? Do we know?
Based on our last written call from November, Your Honor, she stated that she didn't want contact.
She did not want contact.
That's in November.
So if you want, we can do another RIP now to see, they can reach out to her to see what she wants. But until I know that she wants to have contact with him, I'm gonna say last time they talked to her, she said no contact. She didn't want it.
I think
Well,
she's trying to deal with that.
time tends to heal all wounds, Mr. Ratcliffe, but the law never forgets. And if you pick up another one of these, you may very well be looking at a felony next time. You understand? There's an affirmative finding of family violence, meaning that if you pick up another one, they may very well hit you with a third-degree felony. You could be looking at up to 10 years in prison. You pick up another one. How do you plead to this offense? Guilty or not guilty? I'm not going to find you guilty now. I will now withhold that for 6 months to give you the opportunity to complete this. You must do a 2-hour anger management class. No alcohol, no drugs, no weapons. For now, I'm going to put no contact with Ms. Jones. Let's have them reach out to her to see what she wants. If she's okay with it, then we'll do no threatening or harassing. But you got to understand, what is threatening or harassing contact doesn't matter what you think. I don't care what you think. It's what she perceives. So if you go up to her and you go like this, is that threatening or harassing? It most certainly is, and it can land your butt in jail. Do you understand? Okay. Tell me, what are you doing with yourself? Are you working?
Sure.
Okay. You can reduce the fees. It's never about the money. It's about you doing what you say you're going to do, learning, because I tell you what, 99% of the people that we have in jail are there because of one reason. You want to take a guess why? Take a wild shot at it. Why do you think everyone's in custody now?
They're want to learn.
Self-control. They lose it, they wig out, and they do whatever they're going to do without thinking, if I do this, what's going to happen? If I say this, what's going to happen? That's why we do this. You understand? Good luck, Mr. X.
Thank you, Your Honor.
Thanks, Frank. So Farwell, I guess let me know when you do, and then we'll. Okay.
Good morning, Judge.
Hi.
How are you?
Good to see you, Ms. Jones.
Good to see you, Judge. I'm approaching on Mr. Caesar's case, Judge.
I figured.
The first thing I want to address, Judge, is just, that the case continues to dismissed by the state judge.
They're dismissing all of them.
Yes, Judge.
Wow. Lucky Mr.
Caesar.
Mr. Caesar.
Yes, Judge.
Well, if they're dismissed, they're dismissed. There's nothing I can do.
Yes,
Yeah,
Judge.
okay.
I also wanted to just, note, he was taken into custody, I think, because it appears that he got him in the face, Judge, but the actual.
It doesn't matter.
Yeah.
If they're dismissing it, they're dismissing it. It's neither here nor there.
Okay,
So,
so he'll
yeah.
be allowed to.
Yeah, once they file it, I'll sign it, and at that point, he'll be free to go.
And he'll go from here, right?
Yeah. We're not gonna send him down.
Thank you. I'm glad.
Yeah.
Thank you, Judge.
Good job. Hey, Alan, are you ready? Sorry, I didn't even see you there.
Oh, I was actually, filling out my flag last name. I went to a off docket matter, Your Honor, on Wednesday.
Okay.
Her last name is Johnson, first name is, Jonovich. I can give you the.
Yeah, let me just finish this real quick. So. Okay, what's your cause number?
258-6343.
Yeah, okay, I see it.
So, Your Honor, we had reached a deferred, I believe, about a week ago, or maybe 2 weeks ago. You gave us some time and maybe to lift, one of his conditions. You said that you were going to make him required to come back to court to verify that he had enrolled. If he had in fact enrolled, he would not have had to come back to court. He did enroll, and he sent me the proof of it on Saturday. He called for court on, I think it was Monday, whatever day he was set to come to court, to say that he wasn't going to be able to make it to court, but he had already provided the information. I came to court, I was stuck upstairs in the felony case. I came to court by the time I got.
Last time we came here, he did not provide it to you.
No, so when he was required to provide it just earlier this week, he had provided it to me. I just didn't get down here, by the time I got down here, the doors were closed, and his bond had been revoked, and we raised him.
No, we spoke about it. He wasn't here. He never came in, and he had never given you the proof that he had started like he was.
So I think what happened, Your Honor, was the last time we were here, he actually entered his plea. So he was given the 2 weeks to be able to enroll. Because he just entered the plea 2 weeks ago. You told him that you were gonna set him every 2 weeks to verify that he was coming even after he got in class.
So what do you tell him? What would you like?
I'd like to have his bond.
Is Mr. Johnson here now?
He's not here.
He's got to be here, man. I mean, this case is super old. He was supposed to sign up. He didn't show up, you know? What has he done?
I mean, he's attending class. He didn't just sign up.
Show me.
Class.
Good.
You can look at those.
Okay, he says, I found the class to do tomorrow. He's not provided proof of enrollment. He's not provided proof that he's paid for the class. No. He's got to either be here or have actual proof that he's enrolled and he has started to attend. He's done neither, so it stays the way it is. It's a super old case. He's supposed to be here. He failed to appear and he hasn't done anything. Him telling me, oh, by the way, I started it. Yeah, sure. This world is about proof.
Yes, Ron.
Yeah. All right.
Thanks, Dave.
Thanks. You want to go through the list or? I got it.
Oh, you got it, okay. I was also looking at it, I guess, you do the process. Yeah, so, I guess because of this new case, because he has two cases, yes, so he has the interference, and that was the setting date on that was the 13th. So I guess not capacity for that, because you did that yesterday. Okay, so, and it's some of the.
You have a big one?
Yeah, courtroom.
Yeah. Hi, Mr. Adamo. So don't process that.
Right.
No, the withdrawal.
Right.
Not yet. Let me,
So is that right?
yeah,
Very good, I told them. You probably didn't make it up. It's either us or she wanted to.
right. Okay.
Still wanted to.
No. No. I guess SFBF, let's let, if you don't mind, SFBF Monday and let's, yeah, please. Okay, Mr. Adamo, who's your client?
Judge, it's Cooligan, Ligan.
Okay,
We were waiting for, we had applied.
yeah, I think that
We found out this morning he did he's been not been approved.
oh, really? Got denied?
DA's office because of 19 and, something.
A prior deed got in charge fairly recently.
Oh, well,
Sam Junior there wants to appeal it. And,
okay, great. Let him know he's got a week because it's already 221 days old. Let him know he's got a week. And then from now on, the defendant's got to be here. It's just way too old. So we'll set you off for a week. The defendant's got to be here at the next setting and then let him know to appeal it today. That way they've got at least a week to get it done and then we'll go from there. Please. Thanks. Sure. You too.
No, they don't. Which day? What is that?
Toby, do you have an arraignment?
Yes, well, it's a little help with that. It's a, I have a 2B that we learned about, so we got a PSR done. We're gonna.
You want to bring him up to get it done? Please. And what's the last name?
Rodriguez.
Yeah, I'm gonna need it if you don't mind.
261-7929. Currently, refile, it was a felony, they dismissed it, he didn't know about it, and refiled.
Wow. Okay.
Fortunately, bond companies knew about it, even though it didn't show a whole lot. Around.
Can I borrow one of you, please? Roger, it's R, so it's you. All right, Roger, I have to give you a cause number.
And the call number is 2B.
You got it?
261-792.
Did you get it, Victoria?
Yes, Judge, I have.
Okay. All right, you are Mr. Rodriguez. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Okay.
Reading from the DIMS, Your Honor. Complainant stated that on February 21st, the defendant called her, her brother Anthony, or her brother, his girlfriend and his younger sister into the master bedroom to discuss an issue. Complainant stated she was sitting on the edge of the bed. The defendant was in a chair in front of her. She stated she took her phone out to adjust the noise or brightness when the defendant suddenly got up. Because it is not uncommon for him. I'm sorry, Your Honor. The defendant suddenly got up like he might do something because it's not uncommon for him to hit or slap them. Complainant told defendant if he touched her, she would call the police. Complainant stated defendant grabbed her by her hair on the top of her head. Complainant tried to fight back. The defendant pushed her back down onto the bed. Complainant further stated defendant yanked her down to the floor and then back to the bed while holding her hair. She stated she thought her neck was going to tear and she had a hard time breathing. Complainant stated at one point the defendant had her stomach pulled down by her legs. And complainant stated at one point defendant had her stomach pulled down by her legs as he kept a hold of her hair, rushing her neck forward, making it to where she could not breathe for about 5 seconds. Complainant further stated a chunk of her hair was pulled out and left a bald spot on the top of her head, which also caused pain. Complainant was living with defendant on the day of the incident, but has since moved and does seek to pursue charges.
Look, it is his 18-year-old daughter.
The complaining witness is that.
It's his daughter, so sort of.
So it's not I thought you said it was a wife?
Checking the DIMS, Your Honor.
Regardless, Mr. Rodriguez, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to have any contact with this person whatsoever and not to be in possession of any weapons. I'm entering now what's called a magistrate's order for emergency protection, which is a court order that identifies Ms. Rodriguez as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat of harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. If you violate this, the state can and probably will file a violation of a protective order. That's one of the worst cases you can pick up. Do you understand? Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with him. If he tells me he cannot get a hold of you because you're ducking and dodging or whatever reason, then likewise, I will revoke your bond. This is not a revolving door. If I have to put you in jail, no more PR bonds for you. Do you understand? Okay. Do you mind finding those conditions, no contact, no weapons? There's already a MOAP in the system for him to sign bond. We need to talk about a bond. What do you think?
Judge, I was gonna ask for a PR bond and some amount, a couple things. Criminal history 30 years ago, beyond that,
Yeah.
and recently, obviously, it was a little confusing there, but it is his daughter. I think when you heard girlfriend, it was his son and his son's girlfriend. So the idea was they were gonna have a family discussion, and it's probably discipline that got a little out of hand, understanding why we're here. Clearly found out about this and immediately took action. We think he'll show up in court. He won't be a flight risk and professional guy who will abide by your conditions. So we're asking for a PR bond.
$10,000, Your Honor, given the nature of the assault and allegations, I believe
Are you opposed to a PR bond?
we would be opposed to PR bond.
There is a prior assault. It's clearly not the same complaining witness, is it?
Different complaint witness, Your Honor.
Okay. I'm going to set your bond at $5,000. I will grant you a PR bond, but like I said, you're not going to get multiple ones. You get one. Do you understand? All right, so we're gonna have bond conditions created for you to sign. Once you sign them, we'll have another set of conditions for you to sign. Once you sign those, at that point, you'll be free to go. We'll have you meet with Veronica for with pretrial services to process the bond paperwork for you. For now, we'll have you sign a receipt, and then I'm gonna have you take your signature box, okay? Or actually, yeah, come up, we'll have you sign them.
Yeah, probably more things for you to do. Okay. All right.
Judge, what was the bond set?
5,000 and then PR bond grant.
Judge, I did have one more. First,
Yes.
when we're done. The one at Carrie, who was here last week, in good setting. So about him getting a job, read in the riot act a little bit and tried to encourage him to do that. He has shown me text messages and proof that he's been hired by a BJ Smokehouse.
Great.
Basically a server.
Wonderful.
Make $10 an hour. Start at the bottom, but we're starting somewhere. So.
Anywhere, somewhere.
That's right.
Working keeps you out of trouble, so stay out of trouble. Do you understand? We're not asking for much. Okay, we'll give you a reset.
Okay, thank you, Judge.
Happy Friday.
Yeah, thank you. Sure, yes.
He's in processing, that's why.
Okay. I mean, you want me to stay on it or you want to just put?
Please, because it's old, you already know about it.
Okay.
It would be.
Tear it up, please.
Yeah. It's gonna be a whole hell of a lot more headache. So we did SFBF for Monday. Just if you don't mind, let mom know that he's gonna be here Monday. BVR.
Yeah.
You can always zoom in too if you have other
I'm here,
obligations.
but I'm gonna get you have a site. There's something.
But whatever you think, whatever. You think.
All right, thank you.
Thanks, man. Can I somehow make the notation electronically on this thing?
Yes, you can, and this one.
I tried.
And if you go down to, it should, when you do checkout, it doesn't do it, if not, I can do it for you.
No, well, look, check out here.
Yes, just like that, and then normally a PDF form will pop up for you. In your case, I'm not sure if it's the same. But
Open up.
if you tell me, I can do it for you as well.
Yeah, it's just all of them at 90.
Okay, and if you notice, this one is different, and this one will actually has the slot where you can check off, if you go down to page 5, you look right there. Either 91 or 120. There's probably because you just have one. But you still have one, right?
You want to do it?
I can do it. No, I can do it here. I can do it here if you're comfortable.
I'm trying to see you don't have more work to do, but
No,
I just don't,
that's
if you
fine.
teach me how to do it, that way you don't
I
have to
think it's
do it.
because, we go to our settings and we have to set it up so we can, these documents can pop up as PDF. It's no big deal. No, normally when we do, grant or denied on the other forms, we do the checkout.
So undo my checkout?
Yes, and then I'll just, do the 91 for you.
Weird.
Yeah, I'll have to play around with your screen, 'cause I'm not sure how it is for y'all.
All right, you want to go through the list?
Yes, Judge. And then don't forget to bottom of 5.
Oh. Okay,
Email them said I didn't have a right.
SFBF Monday.
Top of 9, failed to appear, 7 more arraignment.
2501.
rise and low, that one fell to appear.
At 10,002 on both of them.
Bottom of 10, simple arraignment to laws posted.
5,002.
Were you appeals on those last two?
I did too. I already on Gian?
Okay,
Yeah, I did.
so then just Jenkins.
Jenkins. Okay.
But just one of us. This is.
Okay, who's next?
Just top of 13, please fell to appear. That was just said, you don't count that.
Yeah. 10,002.
Thank you, Stephen.
Okay. Ah, crap. What did I do?
Bottom of 15, for arraignment fell to appear.
2501.
Top of 16,
6,002. I'm sorry, 5,002.
all right, bottom of 17 was an arraignment yesterday that fell to appear, and today.
Who? Say it again?
Bottom of 17.
Oh, yeah. 2501.
And then page 20, bottom of 20, top of 21,
Okay.
simple arraignment fell to appear.
5,001 on both.
Top of 23, BBR.
Hey, bottom of page 21. Dude's supposed to get an interlock.
It was on the jail docket, rolled for today, and I don't know what the bond paperwork says. Now he's making this straight. So,
Weed?
Okay, I'll come back and check.
Council did show up, and I said, I don't know what his court date is on the bond paperwork, so we were rolling it for Monday.
Yeah, SFBF for Monday then. Yeah. But we need to make sure he gets an interloan.
I'll make it. Top of 23, look at the key on.
Oh, was 5,001. It's gone.
Council taking it out of the courtroom for page 11, bottom of 11, top of 12.
Yeah. Hey, come here. Come here.
Oh.
I have something for you. You want a big lollipop?
Yeah.
These are my favorite. Come on. These are my favorite. I munch on these and I've broken all my teeth because of it. I literally have broken all my teeth. Good luck. You said something.
Yes, Judge, bottom of 11, top of 12.
Yeah, where's Jillian now? Is the defendant here?
Yes, Judge, we checked the. It's gonna be a new judge.
Got it.
Yes.
Hold on. He wants to take a picture? Yes, absolutely. You want to go in front or up here? Come on up. Give me a second. Ready?
Yes. All right. 1, 2, 3. Say thank you.
Good luck. Yes, absolutely. You're welcome back anytime. Come around.
You want to say that a string?
I sure did. Yes. So this is like a way of for some reason, it's how, and so you are still,
That's insane. Well, it's flat. That's a lot of that. Yeah, yeah. Yeah. So you do have. Yeah, it's still. Other than software, it's not. Over. You're reading a box. And one. Yeah, I feel like that, maybe.
Hopefully maybe.
Yeah, that is all the time. That's why I didn't have a see all of us. Okay. Yeah, who's good? Who's everybody. Both mom and company on it anyway, summer. Okay, so well, the 20th. Because you have no, you're saying like, because you go back on the trail and have all this stuff on this. And this is kind of like. Oh, right. Yeah, okay.
Yeah. Most of them forgot the right sheet.
Okay, she'll be right out. You might use the internet. Yeah. Very sure. Because on their list, I know to publish after the warrant, they have the warrant and stuff on it, right? They're gonna follow it. Okay. But just the other thing is so like, yeah. What? Oh, no, in the. And then republish.
I vote to be the power of the state. You need the power of the state. I mean, still, I get. I don't know. Yes. Slash the wall in look, that's not. We talked. Nobody showed every bill. Go to that. Nobody there. Okay. And then,
Thank you. Yeah, is it because this is not a person who knows it's going to move on over here? I'm sure. Okay. Yeah, we figured babies are in the future. It's all right. You know, it's a lot of.
All right. Anything else?
Wait on that, please. Page 11 and 12.
Okay.
Mr. Ripley, his CPR on this.
Yes, I'll send her right now.
And then Anthony.
Got it. Okay, I'm signing everything now. Actually, yeah. Done.
It's currently ready for publish to assign the defendant in new, it was a GPS prior release within the base of the sales.
Yeah, you want me to undo it or?
If you want to do a signature and then.
Yeah, it's Cobble. Hey, where is it? It's Cobble. Is it ready? Ready to publish. Can I undo the signing and then we just kill it?
Yes, yes, you can have that, and it should be back and ready for activities. It has the comment saying.
Ah, I see. Okay, got it. Okay.
Thank you, Judge.
What else? Oh, that's it? Okay, yeah, done.
Can I get your please sign?
Yeah,
254.
okay.
7148. He's from the transfer to Eastern California. He was 15 cases, one for battery and one for D.
Issue a warrant.
What do we want to say?
5,001. The gentleman with the backpack over there, who's this gentleman? Oh, okay.
Yeah.
Now, we're close, I think. We're close. And back there, is that the plea? Oh, that, who's,
There's.
where, who? Oh, that's her, okay.
I emailed Jill, I just emailed her, I thought they were outside talking, but she was trying to contact Jill. Jill had to run to another. No, and then I had to give him some. June last month.
So Gammon has bond violations again. Veronica, you see that?
I think you would, just wanted to make someone over, hey, we're just trying to do some shit. You know? Yeah. I think that he's, you don't,
Bye, guys. Have fun. Come on, Jillian.
I don't think I've made it.
Get that information. Yeah. So I mean, I'll leave it out for a minute and then try to call the stage. Maybe scroll my days. Okay.
Hello? Jillian.
You gotta roll it to Monday.
Uh-oh. Someone's not happy.
I'm gonna be sick on Monday.
Wow, you made it. You made the cut.
I'm not earlier, but
You ready?
they're trying to get your life sentence on it. You gotta back with the action.
Is it capital or what?
We can do it. You put it? Okay.
And that's interstate compact.
Y'all agree?
Take care.
Bye, Judge.
Do you have anyone else back there?
No, Judge, he had the last one that was finished.
Okay. Anyone else? We gotta get that and then Mr. Rodriguez out.
Oh.
Okay.
Well, Rodriguez was state bond conditions, right?
Yeah, it's ready.
Oh,
You're ready. Back, I'm talking right. That was a phone call.
Veronica, do you still have the recess? Yeah. Are you done? Just like say one conditions and then
Yeah.
Right down.
I don't think that is a reaction one kind of day, but I don't think it was necessary. Brian, informing them. That's kind of the middle of the thing. What's that? And again, the other place. They did the AR. So there. If they get something off from that. You know, they can look at it. I believe you, because you're saying makes sense, so it wasn't suspended. I'm not sure. So.
Ready?
Not yet, sorry.
Yeah.
Where did John go?
He's in court 15. They only have one person, and they're the chief.
Is he floating all over the place then?
There's a chief retreat today, so he's the only.
Oh, that's right. Is it the division chief?
Deputy for the. Well,
Oh, for just the floor. Got it. Okay. So all the chiefs are out. But we still don't have one though. I mean, he will be ours
He'll be
here,
our court chief as well.
our court chief, as well as the deputy.
Yes.
So he'll be here.
Will he have the power to say yay or nay to diversions?
Yes, he can do all of them, yes.
Great. So we don't have to reach out to anyone anymore now that he's here. Great. Now we can be more efficient, you know? Wonderful. Hey, why was she kicked out? Why was she kicked out?
How did you skip flows and she tested positive for. And pull it up.
I guess I can see if I can pull it up too.
I think it might have met.
What? Really?
But she, I mean, based on her explanation.
Okay.
And then
So are you going to, is there any restitution that's available?
there was no damage. There was a house and a vehicle. That was it. There was no damage to the house, and the vehicle was insurance covered damage.
I know, but someone has to still pay for a deductible.
I haven't talked to the complainant yet about that one.
Please. All right. Ms. Martinez, you were placed in a diversion program for the DWI and the failure to stop and give information. It's come to my attention that they kicked you out of the program and you're now pleading guilty to this DWI. Is this correct?
Yes.
You need to understand that this charge will go on your record. It will be there for the rest of your life. If you ever pick up another one, you'll be facing a minimum of 90 days in jail. There are no more proverbial slaps on the wrist. Do you understand? I'm assuming the case will be dismissed.
Yes,
Is
sir.
it? Okay.
Yes, Judge.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, the right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this, once you plead guilty to this, you can never change this. It will be like this for the rest of your life. Is this what you want to do? How do you plead to the offense? Guilty of DWI, guilty or not guilty? I'm going to find you guilty. I have to suspend your license. I'm going to suspend it for 180 days. Do not drive until you get a license. I'm now also going to waive around $6,500 of fines and fees and surcharges for you now. If you pick up a second DWI, it is a $6,000 surcharge. And if you don't pay it, every $100 that you owe, you will sit 1 day in jail. You understand? All right. Good luck to you, man.
Thank you.
Thanks, Jimmy. And that's my
Yes.